Imagine, just for a second, that you have a local public park right in your neighborhood.
Okay, I'm picturing it.
Right, and you and your friends have been going there for years. It's like the place where you hang out after work.
Yeah.
It's where you share inside jokes.
Yeah.
It's basically a core part of your community's identity.
Yeah, everyone has a spot like that.
Exactly. So then you wake up one morning, you stroll down to the park with your coffee, and there is this giant chain-link fence erected completely around the perimeter.
Oh, wow, just overnight.
Just overnight.
Yeah.
And sitting in a newly built toll booth is a total stranger. They are holding a legally binding piece of paper from the federal government, and they're demanding you pay them $3 every single time you want to use the swings.
I mean, people would lose their minds.
Right. Your immediate reaction would probably be utter confusion, followed closely by just absolute outrage. You'd think, wait, nobody owns this park. This belongs to all of us. You can't just put a fence around something we all built together.
Yeah, and that is the exact instinct we all have in the physical world. We implicitly understand this concept of a commons.
Right, a public space.
Exactly. We know what a public space is, and we know that certain things belong to the community as a whole. But when we transition into the digital world, into the realm of language, memes, hashtags, and internet subcultures, those physical boundaries suddenly become invisible.
They just kind of vanish.
They do. And human history shows us that whenever something valuable is invisible or legally ambiguous, someone eventually is going to try to build a fence around it.
Which is such a wild concept. And welcome to today's Deep Dive. We are so thrilled you're joining us because today we are venturing into a uniquely modern, rapidly evolving battlefield.
It really is a battlefield out there.
It is. We're looking at the violent collision of intellectual property law in internet subcultures. And specifically, we're going to look at a massive controversy that recently set the entire online literary world on fire. It revolves around a simple three-word phrase, which is, hot girls read.
It is a genuinely fascinating case study in how modern digital culture operates and, frankly, how ill-equipped our legal frameworks are to handle it.
Totally ill-equipped.
Yeah. And to really understand the mechanics of what happened here, we're not just looking at one perspective. We are synthesizing a massive stack of source material today.
We really dug in.
We did. We're diving into the official federal records from the United States Patent and Trademark Office. We're looking at archived e-commerce storefront data that internet sleuths pulled from the Wayback Machine.
Because the internet never forgets.
Exactly. We also have this really illuminating entrepreneur profile from Canvas Rebel magazine that gives us the psychological background of the creator at the center of this. And to understand the legal realities, we are looking at detailed legal analyses from intellectual property law firms like Keen Miller and Gerben IP.
And all of that is layered on top of the minute-by-minute community discourse from Reddit, Threads, and BookTok, right?
Yep, the real-time reactions.
So the mission for our deep dive today is to untangle this digital mystery for you. We are going to figure out the how and the why. How did a single internet creator managed to legally own a piece of communal language?
And how did a decentralized online community use this incredibly savvy legal and financial strategy to fight back?
Right. And ultimately, what does this mean for the future of the culture you consume and participate in online? Okay, let's unpack this.
Let's do it.
I want you to put yourself in the shoes of an independent creator. Imagine waking up one day to find that a phrase you and your friends use every single day online, a phrase you might even sell on a t-shirt or a coffee mug on Etsy to help pay your rent, is suddenly owned by a total stranger.
Just ripped right out from under you.
Yeah. And that stranger is now legally demanding that you stop using it immediately.
And that hypothetical nightmare became a very stark reality on June 3, 2026.
The day it all kicked off.
Exactly. A 26-year-old content creator and small business owner named Ali Mitrovich, who operates under the corporate name Ali Rose Co., posted what she thought would be a celebratory announcement on her Instagram account.
She really thought people would be happy for her.
She did. She excitedly informed her audience of over 60,000 followers that after a long legal process, she had successfully secured a federal trademark for the exact phrase, "hot girls read."
I actually pulled up the exact wording of that Instagram post from the archival sources, and I have to read this because she didn't just announce the trademark as a fun fact. She included a direct, actionable demand to her peers in the space.
What did she say exactly?
She wrote, and I quote, "I've seen HGR on lots of items from other businesses that follow me, so if that is you, please remove those listings from her site as soon as possible, with love."
And then she added 4 exclamation points and a yellow heart emoji.
Oh, wow. The yellow heart emoji. Right. The with love part, combined with the heart emoji, really seemed to act as an accelerant to the fire. Like looking at the Reddit threads discussing this, that specific phrasing was viewed as incredibly condescending.
The reaction was visceral. And to understand why the community perceived it as so patronizing, we really have to look at who Ali Mitrovich is, and more importantly, how she built her entire brand.
Right, her origin story.
Yeah, the Canvas Rebel magazine profile on her gives us incredible insight into her origins. She is a graphic design graduate who finished her degree in 2020, right at the absolute peak of the COVID-19 pandemic lockdowns.
Oh, right. The profile mentioned she actually got sent home from college in March of 2020. She was trapped in quarantine. She was bored. And like a lot of people during that specific cultural moment, she decided to buy a Cricut machine.
A classic pandemic hobby.
Exactly. For those who don't know, a Cricut is a digital craft cutting machine that lets you design and cut your own vinyl stickers or iron-on decals. So she started making stickers in her bedroom just to pass the time, selling them to friends and family.
And then the algorithm got hold of her.
It did. She filmed herself making a sticker, posted the process on TikTok, and boom, it went completely viral.
And that single viral moment really became the structural foundation of Ali Rose Co., which she officially launched as a business in September 2020.
She capitalized on it quickly.
Very quickly. But what is critical to understand here, and what makes the later betrayal feel so acute to the community, is the marketing strategy she employed. In that Canvas Rebel interview, she explicitly credits her business success to social media vulnerability.
Ah, so she wasn't playing the big corporate card.
Not at all. She didn't act like a faceless corporation. She set up her camera in her bedroom while she packed orders. She filmed herself designing new products.
Really bringing the audience into the process.
Exactly. She talked openly to her camera about the struggles of being a solo entrepreneur in her 20s. She talked about how lonely it can be without coworkers, the overwhelming stress of navigating health insurance, and the nightmare of doing self-employment taxes.
I mean, she systematically built a parasocial relationship with her audience. She explicitly stated that she talked to her followers online as though they had been friends forever.
Which is a brilliant strategy, usually.
And to be fair to her, it worked brilliantly. She grew this highly successful mini online boutique selling t-shirts, sweatshirts, stickers, and stationery based entirely on the goodwill of that community. But here is the massive, unavoidable problem that ignited the entire internet.
And what's that?
Ali Rose did not invent the phrase "hot girls read." She didn't coin it. She didn't popularize it. She just scraped it off the internet.
Exactly. And this is where we have to dive into the sociolinguistic origins of the phrase itself, because it traces back much further than her 2020 bedroom business.
Oh, way further.
The phrase hot girls read owes its entire existence to the broader hot girl internet vernacular. And that vernacular was created and popularized by the Grammy-winning musical artist Megan Thee Stallion.
Yes. Megan Thee Stallion released the song Hot Girl in 2018, and then in 2019, she picked off the massive cultural movement known as Hot Girl Summer.
Right, which was everywhere.
It was inescapable. And what's so interesting about internet linguistics is how a phrase from African-American vernacular English, popularized in the rap community, gets adopted, adapted, and eventually memified by the broader internet.
It acts as a linguistic template, really. The original phrase hot girl summer was about confidence, living your truth, and having fun. But the internet loves a modular meme.
A modular meme, I like that. Like a fill-in-the-blank.
Exactly, a fill-in-the-blank structure. So hot girl summer evolved into a snow clone, a customizable phrase. People started saying hot girls walk to describe taking a mental health stroll.
Right, the hot girl walk was huge on TikTok.
Huge. Then it became hot girls have stomach problems as a sort of ironic, self-deprecating humor. And inevitably, as this linguistic framework filtered into the online literary subcultures like BookTok and Bookstagram, it organically morphed into hot girls read.
It was a collective inside joke. It was an identity marker that just organically bubbled up from the digital ether. It was a way for young women to say, hey, reading isn't just for quiet introverts in libraries. Reading is cool. Reading is confident.
A total cultural shift.
And by the time Ali Rose announced her trademark in 2026, the phrase was absolutely everywhere. We're talking about independent Etsy sellers, massive book influencers, and even major corporate retailers.
Right. The sources note that Barnes & Noble and PopSocket, these are huge corporate entities, were utilizing variations of this phrase.
They're cashing in on it, too.
Oh, big time. One specific data point from the sources noted that prior to Ali's announcement, A simple search on Etsy yielded over 5,000 distinct product listings utilizing the phrase, "hot girls read."
5,000. That is wild.
So frame the conflict here. You have a phrase that functions entirely as a piece of shared cultural vocabulary. It is a communal asset.
A public park.
Exactly, the park. Then suddenly, it is claimed as private, monetized property by one individual who didn't coin it, who built her brand on the idea of being a vulnerable, community-focused peer.
The betrayal factor is so high.
It is. The dissonance between how the community viewed the phrase and how Allie Rose viewed it as a proprietary brand asset was the spark that lit the powder keg.
I hear that. And looking at the sheer volume of users, I see exactly why people were angry. But I want to play devil's advocate for a second here.
Okay, go for it.
Isn't what she did essentially the American dream?
Right.
My analogy for this is it's like someone figuring out how to bottle rainwater.
Rainwater.
Yeah, like the water was always there. It was falling on everyone's heads. Anyone could have caught it. But she's the one who took the initiative to go outside, bring the buckets, build the bottling plant, and actually file the complex paperwork with the federal government.
So she did the legwork.
Right. Shouldn't she be rewarded for having the business savvy to actually go out and claim it before anyone else did?
I see why you'd use that analogy, and in a purely capitalistic vacuum, it makes a certain kind of sense. But what's fascinating here is that intellectual property law actively and aggressively rejects that exact premise.
Wait, really?
Yes. We have a detailed legal analysis provided by Keene Miller, an intellectual property law firm, and they put it perfectly. Trademark law does not exist to reward cleverness. It exists to reward distinctiveness.
Wait, I need you to slow down and unpack that for me.
Yeah.
Because to the average person, cleverness and distinctiveness sound like the exact same thing. What is the actual difference in the eyes of the law?
To understand the difference, we have to look at the fundamental foundational purpose of why a trademark exists in the first place.
Okay.
A trademark is not a reward for inventing a cool phrase. A trademark exists solely to identify the source of a product or service. Its entire legal purpose is to prevent consumer confusion in the marketplace.
So it's about protecting the buyer.
Exactly. When you are walking down the street and you see the Nike swoosh logo, or you read the phrase, "just do it" on a billboard, your brain does not think, "Wow, what a clever sentence."
No, I just think of shoes.
Right. Your brain immediately, subconsciously associates those goods with the specific origin, the Nike Corporation. That phrase has acquired what the law calls distinctiveness. It is a beacon pointing directly to the manufacturer.
Okay, I get it. It's a cognitive shortcut for the consumer's brain. It tells me who made the thing I'm buying.
Precisely. But when a consumer encounters a ubiquitous cultural phrase, their brain processes the information entirely differently.
Like with a meme.
Yeah. When someone sees "hot girls read" printed on a canvas tote bag at a bookstore, they aren't looking at that bag and thinking, this high-quality canvas receptacle was manufactured and distributed by the Allie Rose Corporation of Colorado.
Definitely not. They're probably just thinking, hey, that's me.
Exactly. They are thinking, this is a fun, relatable message that expresses my personal identity and my hobbies. The phrase is communicating a cultural message. It is not communicating a brand origin.
I see.
So going back to your rainwater analogy, if a phrase is just rainwater, trademark law says it belongs to the clouds, to everyone. It does not belong to the person who happened to hold up a bucket first.
Here's where it gets really interesting to me. If the legal rules clearly state that common ubiquitous phrases shouldn't be trademarked because they don't identify a source, how on earth did the United States Patent and Trademark Office actually grant it to her?
That is the million-dollar question.
Are the people at the USPTO just asleep at the wheel? Because my analogy for the USPTO right now is that they seem less like a rigorous legal authority and more like a bureaucratic DMV clerk.
A DMV clerk, okay.
Yeah. Like, are they just a bouncer at a club who only checks if your ID is physically valid but doesn't check your social media to see if you actually belong to the community you claim to represent?
Mm-hmm.
They aren't acting like private investigators. It seems like if you fill out the form correctly and pay the fee, they just stamp it and move on without checking if you actually own the thing you're claiming.
Your DMV clerk analogy is incredibly accurate, actually, and it strikes at the heart of how the system really functions. To understand how this slipped through, we have to forensically examine the anatomy of this specific trademark application.
Let's dig into the files.
The official USPTO records show that Allie Rose LLC, utilizing the services of a Colorado-based legal firm called Hanning Law Limited, filed the initial application for the literal element "hot girls read" on August 27, 2024.
Wait, August 2024. So she filed this paperwork almost 2 full years before she made her big celebratory Instagram announcement in June 2026.
Yes.
So she was just sitting on this secret for years while all her peers were using it.
She was. The federal trademark prosecution process is notoriously slow, largely due to a massive backlog of applications at the USPTO. It takes time for an examiner to be assigned, for them to review it, and for it to pass through the publication phase.
But years is a long time in internet years.
It's an eternity. This specific mark was officially registered on February 3, 2026, under registration number 813-00042, and we need to look at exactly what she registered it for.
What were the categories?
Under international trademark treaties, known as the NICE classification system, goods and services are divided into categories. Ali Rose registered her phrase under 2 specific classes. First, International Class 0 with Scene, which covers paper goods, think bookmarks, stickers, notebook covers, and notepads.
Okay, her bread and butter.
Right. And second, International Class 025, which covers apparel, specifically sweatshirts, graphic t-shirts, and hooded sweatshirts.
What does that cost?
The filing fee at the USPTO is $350 per class. So this was a deliberate, calculated $700 initial investment on her part.
But I have to go back to my D&V analogy. If 5,000 people are selling this on Etsy, how does a highly trained federal trademark examiner look at this application and say, yep, looks like a unique brand identifier to me, and just stamp it approved?
Josh Gerben from Gerben IP, a prominent trademark law firm, points out in his analysis that while trademark examiners are highly educated attorneys, they are not omniscient.
Right. They don't know everything.
And they are severely limited by their operational constraints. They work almost exclusively from the written record placed before them and internal database searches. They do not have the time, the budget, or the mandate to conduct deep anthropological studies of TikTok microtrends or niche Etsy subcultures.
So they aren't scrolling BookTok on their lunch break.
Probably not. If a phrase hasn't reached the absolute pinnacle of mainstream lexicon, like a phrase you would hear an anchor say on the nightly news, an examiner might mistakenly view it as a unique, creative brand identifier coined by the applicant rather than a common internet meme.
So they essentially missed the cultural context entirely. They looked at the paperwork, saw it was properly formatted, did a quick database check to see if anyone else had registered it, found nothing, and approved it.
Exactly. And the legal analysis from Keen-Mailer highlights a specific, massive legal hurdle that this application should have failed but didn't. The doctrine of ornamentality.
Okay, ELI 5 time. Explain like I'm 5. What is the doctrine of ornamentality?
The USPTO has a strict rule that it routinely uses to refuse the registration of slogans on apparel and merchandise when consumers are likely to view the wording as purely decorative. Let's say you try to trademark the phrase dog mom to print on coffee mugs or coffee addict for t-shirts.
Right, those are just things people say. They don't mean a specific company made them.
Precisely. Dog mom and book shrevert are ornamental phrases. They are decorative statements of self-expression. Because they are decorative, they cannot, by legal definition, function as trademarks.
That makes total sense.
The fact that the USPTO examiner did not immediately issue an ornamentality refusal for Hot Girls Read raised a lot of eyebrows among intellectual property lawyers reviewing this case. But, as Gerben IP notes, examination mistakes happen every single day. A federal trademark registration is a powerful tool, but it is not an invincibility shield.
I'm looking at our source notes here, and this phenomenon of trying to enclose cultural language isn't new. This isn't the first time someone has tried to monopolize a common phrase, right? The sources mention some massive, high-profile historical precedents.
They do, and looking at those precedents helps us understand the mechanics of the backlash. One of the most famous recent examples in the corporate world involved the billionaire athlete LeBron James.
Wait, LeBron James?
Yes. He actually attempted to federally trademark the phrase Taco Tuesday.
I remember when that happened. It felt so incredibly audacious. You have local Mexican restaurants on every corner in America that have been using Taco Tuesday on their chalkboard since the 1980s.
Exactly. Taco Tuesday is a ubiquitous cultural phrase used by thousands of restaurants to denote a weekly dining custom. When LeBron James's legal team filed for it, seemingly to use it for podcasting and entertainment services, the public backlash was immense.
I can imagine.
But the mechanics of why it failed are important. The USPTO ultimately refused the application because the phrase was simply too commonplace. It had become entirely generic.
Makes sense. Any other big ones?
Another massive corporate example was the Walt Disney Company. Ahead of the release of their animated film Coco, Disney actually attempted to trademark the phrase Dia de los Muertos.
Wait, I need to pause on that. A massive American media conglomerate tried to trademark the literal name of an ancient, historical, indigenous cultural holiday.
They absolutely did. They wanted to secure the merchandising rights for apparel and toys. And the mechanics of the pushback there were purely social. The public outcry over the sheer audacity of the cultural appropriation was so intense, so immediate, and so damaging to their brand reputation that Disney was forced to formally withdraw the trademark application before it even reached the registration phase.
Good. That is just wild.
But perhaps the most relevant structural precedent to the Alley Rose situation is a scandal from 2018 that is legendary within the online literary community. It is known simply as Cockeygate.
Cockeygate. I mean, the name alone is incredible. I have the notes here, but I want you to walk me through exactly how that worked, because the mechanics of it seem crucial to understanding why BookTok reacted so violently to Alley Rose.
Cockeygate is the cautionary tale of indie publishing. In 2018, an independent romance author named Felina Hopkins managed to successfully register a trademark for the single word, cocky.
Just the word cocky.
Just the word. She had used the word in the titles of a very successful series of self-published romance novels, books with titles like Cocky Roomie and Cocky Biker. Now, the word cocky is an incredibly common trope identifier in romance fiction.
Oh, absolutely.
But once she held that official trademark registration, she weaponized it. She began sending out aggressive cease and desist letters to other independent authors who had the word cocky anyway in their book titles, demanding they change their titles, redesign their covers, and surrender their profits.
Over a single everyday dictionary word. But here is what I really want to understand. How did she actually enforce it? Because if someone sends me an email saying, change your book title, I might just ignore it. What was the actual mechanism of her power?
The mechanism of power in the digital age is algorithmic compliance. Felina Hopkins didn't just email the authors. She submitted trademark infringement claims directly to Amazon's Kindle Direct Publishing Platform, or KDP.
Going straight to the distributor.
Yes. Under digital copyright and trademark laws, platforms like Amazon and Etsy operate under safe harbor provisions. To avoid being held legally and financially liable for the infringing actions of their users, these massive platforms utilize automated systems. When they receive a formal complaint backed by a federal trademark registration number, their algorithms do not nuance the situation.
They just react.
They do not hold a trial. They shoot first and ask questions later. Amazon automatically suspended the books of the targeted authors. These independent authors literally watched their books disappear from the store, losing thousands of dollars in daily revenue overnight. It was financially devastating for small creators who couldn't afford lawyers to fight back.
That is terrifying. So the platforms, Amazon, Etsy, Redbull, they're so legally terrified of being sued by a massive corporation that their automated systems will blindly enforce a trademark, even if that trademark shouldn't have been granted in the first place.
Exactly. Ultimately, the situation with Cockeygate became so dire that major professional organizations, the Authors Guild and the Romance Writers of America, had to step in.
They had to bring out the big guns.
They did. They pooled their massive legal and financial resources, hired high-powered intellectual property attorneys, and successfully defeated Hopkins in court, forcing the cancellation of the trademark. But the trauma of that event left a permanent scar on the indie literary community. They learned that a bad trademark can destroy your livelihood in an instant.
Which brings us back to Alley Rose and the concept of the enforcement paradox. Because when Alley faced the initial wave of backlash on her Instagram, she quickly pivoted. I'm looking at her follow-up comments, and she started saying things like, guys, don't worry, I won't actually go after small businesses. I only filed this so major corporations like Target couldn't steal my specific sweatshirt designs.
Right, trying to be the hero.
Exactly. She tried to play the role of a benevolent dictator. But the law doesn't actually allow you to do that, does it?
It absolutely does not, and this reveals a fundamental, critical misunderstanding of intellectual property law by lay people. The Keen-Miller analysis breaks this down brilliantly. A trademark is not a passive asset. It is not a plaque you hang on your wall and forget about. If you own a trademark, you have an affirmative, unavoidable legal duty to police it and enforce it against unauthorized third-party use.
Wait, really? So you are legally required to be the bad guy? You have to send the cease and desist letters?
You have to be the enforcer. Let me explain the mechanics of a concept called dilution. Let's say Nike decided to be nice and they publicly announced, hey, Anyone can print just do it on their homemade t-shirts. We won't sue you.
Which they would never do.
Never. But if they did, if they allow widespread unauthorized use of their mark, the mark loses its distinctiveness. It no longer points solely to Nike. It becomes diluted. In the eyes of the law, if you fail to aggressively police your mark, you risk having the trademark declared abandoned. The government will literally strip your rights away. So if Ally Rose allowed 5,000 Etsy sellers to continue selling Hot Girls Read merchandise, her trademark would become worthless. You cannot legally claim exclusive monopolistic rights to a phrase out of one side of your mouth and then publicly announce that the community can freely use it out of the other. Trademark doctrine inherently demands aggressive, unrelenting policing.
Okay, so let's zoom out and summarize exactly where we are in this narrative. We have a 26-year-old influencer who took a communal meme born from African-American vernacular English and popularized by Megan Thee Stallion.
Yep.
She quietly spent 2 years and $700 navigating a flawed, under-resourced USPTO examination process. She secured a legal monopoly over the phrase. She told her peers to stop using it. And because of how trademark law works, she is legally obligated to become a corporate bully to maintain that monopoly. She has successfully built her legal toll booth in the middle of the public digital park.
That is a perfect summary. And what's crucial to understand is that in a pre-internet era, the story almost certainly would have ended right there, because the economics of legal defense are brutal.
How bad are we talking?
If you are a solo creator selling $3 handmade bookmarks on Etsy, and you receive a formal cease and desist letter from a lawyer citing a federal registration number, you capitulate. Hiring an intellectual property attorney just to review the case and draft a single response letter can cost anywhere from $1,500 to $5,000.
Oh my gosh, for a $3 bookmark.
Exactly. Going to trial can cost hundreds of thousands. The math simply does not work for the little guy. You fold, you delete your listings, and the bully wins.
But this isn't the pre-internet era. This is 2026. And if there's one thing we know about BookTok and internet subcultures, it is that they do not mess around when they feel threatened. So what does this all mean? It means the empire struck back.
They absolutely did.
The community didn't just whine in the comment sections, although reading through these Reddit sources, they did a staggering amount of complaining. But they actually organized. They executed an unprecedented, highly sophisticated legal and financial counterattack.
The speed, the precision, and the coordination of the community's response was truly remarkable. They intuitively understood that while an individual Etsy creator couldn't afford the thousands of dollars required to fight a federal trademark, the collective community could easily absorb the cost.
Strength in numbers.
Yes.
Yeah.
A fantasy author named Michelle Khalil, who operates legally under the name Michelle Judith Guarnieri, stepped up to lead the charge. She launched a GoFundMe campaign with a very clear, focused title: Stand with Small Book Creators Against Trademark Abuse.
I love the mechanics of this.
Yeah.
How quickly did they actually raise the funds? Because the GoFundMe campaigns can sometimes linger for months.
This one did not linger. Within 3 days, the campaign raised over $2,000 from 62 individual donors. We're talking about community members, people like Soraya Wilson, Summer Seeds, Melissa Bachman woodchipping in $25, $50, $100 at a time. It was the ultimate democratization of legal defense.
And what's brilliant is that they knew exactly what to do with that money. This wasn't just a vague, general legal defense fund that might get drained by endless hourly attorney fees. They had a surgical, specific legal target in mind.
Yes. They aimed directly at the heart of the registration. On June 5, 2026, which, keep in mind, is just 2 days after Ally Rose posted her initial celebratory Instagram announcement, Michelle Guarnieri used those crowdfunded resources to file a formal petition for cancellation with the Trademark Trial and Appeal Board.
TTAB.
A TTAB, right. It's the administrative court within the USPTO that handles these disputes. This specific proceeding was officially docketed under number 920-91888.
I want to break down the economics of this counterstrike, because it is a masterclass in asymmetrical digital warfare. We know Ally paid $350 to $50 per class to register it, totaling $700. How much does it actually cost the community to legally challenge it at the TTAs?
The required federal filing fee for a TTA cancellation petition is $600 per international class. Since Ally Rose had registered the mark in 2 classes, Class 01 Scene for the paper goods and Class Euro 25 for the apparel, the total filing fee to challenge both classes was exactly $1,200.
Okay, so the math works out perfectly.
It does. The GoFundMe hit $2,000, which covered the federal fees entirely and left an $800 buffer for additional legal consultation or administrative costs.
It is a perfect, shining example of the power of decentralized networks. One person making stickers in their kitchen cannot afford $1,200 to fight a $700 federal filing, but 62 people pooling their pocket change can afford it instantly.
It's beautiful, really.
It is. But let's get into the legal weeds here. Once that TTB cancellation petition is filed, what is the actual legal argument? It's not enough to just say, we don't like her. How do you legally prove she shouldn't have the trademark?
The mechanism for cancellation is governed by 15 U.S.C. Section 1064, which states that any person who believes they will be damaged by the registration of a mark can petition to cancel it. The community's primary legal arguments were rock solid. They argued prior third-party use, meaning thousands of people used it before her, genericness, and descriptiveness.
Okay, those are the standard arguments.
Right. But to ensure absolute, undeniable victory, the internet sleuths didn't just rely on general arguments. They started forensically digging into the official USPTO application documents Allie had submitted. And what they found was a massive fatal flaw.
Oh, the timeline lie. I absolutely love this part. This is where the reality of internet culture becomes incredibly dangerous for anyone trying to pull a fast one. Tell us about the dates on the paperwork.
When you apply for a federal trademark, you must declare, under penalty of perjury, the exact date you first used the mark in commerce. This is a sworn statement. On her federal application, Allie Rose claimed a first use in commerce date of January 14th, 2021.
Okay, January 14th, 2021. On its face, that sounds plausible enough. The Canvas Rebel profile told us she started her business in late 2020, so early 2021 makes sense.
It sounds entirely plausible to a USPTO examiner looking at a piece of paper. It completely falls apart when a mob of highly motivated internet sleuths pulls up your archived digital footprint.
Oh, no.
Oh, yes. The BookTok community went back through years of her YouTube and TikTok videos, and they found vlog footage of Allie Mitrovich explicitly admitting to her audience that she didn't even start reading books or enter the online literary space until 2023.
Wait, what?
Yeah. When she started her business in 2020 and 2021, she originally sold standard, generic apparel and aesthetic stickers. She did not pivot her business model to bookish merchandise until 2 full years after the date she swore to on her federal trademark application.
So she lied on a federal legal document. She claimed, under penalty of perjury, to be selling hot girls read merchandise before she even liked reading books. That is staggering.
It was the smoking gun. It provided the petitioner, Michelle Garnier, with incredibly strong documented grounds to argue that the registration was obtained through material misrepresentation, essentially fraud on the USPTO.
Wow. Game over.
You'd think so. But the community, fueled by absolute outrage, didn't stop there. They didn't just audit the trademark paperwork. They decided to audit Allie Roscoe's entire e-commerce storefront.
And what they found was that Allie Rose was throwing legal stones from a house made entirely of highly fragile intellectual property glass.
Exactly.
So what does this all mean? Let's paint the picture. She is aggressively demanding that other independent creators take down their homemade Hot Girls Read merchandise, claiming they are violating her sacred legal rights. But when the internet sleuths looked at what she was selling to make her money, what did they find?
They found a storefront absolutely packed with heavily infringing, unlicensed merchandise based on the intellectual property of some of the most litigious global corporations and celebrities on the planet.
Just a treasure trove of infringement.
The community began compiling a devastating itemized list of what Allie called her color swatch bookmarks, which retailed on her site for $3 each.
Let's list these off, because when I read the sources, my jaw actually dropped. The sheer hypocrisy is genuinely shocking.
It is a masterclass in IP infringement. First, she had bookmarks utilizing the character names, specific locations, and titles from the A Court of Thorns and Roses series, widely known as Akutar. This is the closely guarded intellectual property of mega best-selling author Sarah J. Maas and Bloomsbury Publishing.
And they do not play around.
Not at all. Next, she had bookmarks based directly on Taylor Swift's The Eras Tour, utilizing the tour's specific branding and album thematic concepts. And those are clear, actionable violations of TAS rights management, Taylor Swift's famously aggressive legal team.
Never cross Taylor Swift's lawyers.
Good rule of thumb. She also had Harry Potter bookmarks, infringing on the rights of J.K. Rowling and Warner Bros. Discovery. She even had merchandise based on romance authors like Colleen Hoover and Tessa Bailey, and the NBC television show The Office.
But here is the kicker. It wasn't just the words on the bookmarks that were stolen, right? It was the actual visual design framework she used to sell them.
Correct. The overarching color swatch design she utilized for all of these bookmarks was an exact, uncredited replica of the iconic color chip layout owned by Pantone LLC.
Like the paint company.
Yes. If you picture a Pantone color swatch, the solid block of color taking up the top majority of the card, with a specific white horizontal margin at the bottom containing the text and numbers, that exact layout is legally protected.
Wait, let's pause. This brings up a term we haven't defined yet, trade dress. How is trade dress different from a copyright or a trademark? How can a company own a layout of colors?
It's a great question. Copyright protects a specific creative work, like the text of a novel or a painting. A trademark protects a brand name or a logo, like the word Pantone. Trade dress is a subset of trademark law that protects the overall visual appearance of a product or its packaging, provided that the appearance signifies the source of the product to consumers.
Can you give an example?
Sure, think of the distinctive, contoured glass shape of a Coca-Cola bottle. Even if you took the label off, you'd know it was a Coke bottle. That shape is trade dress. The specific standardized layout of a Pantone color chip is heavily protected trade dress. So by combining unlicensed literary and musical IP with unlicensed Pantone trade dress, Allie Rose had essentially created a product that was a magnet for devastating corporate litigation from multiple angles simultaneously.
It is truly staggering hubris. She spent $700 and waited 2 years to legally weaponize a meme against her peers, all while her own primary revenue stream was built on flagrantly ripping off Disney, Taylor Swift, Sarah J. Maas, and Pantone.
It really is something.
But if we connect this back to the bigger picture of e-commerce, I just keep asking myself, why risk it? If she had a highly successful business making cute, albeit infringing, merch, making a good living, why poke the bear? Why draw attention to yourself by filing this aggressive trademark? Was it purely just an ego trip?
If we connect this to the bigger picture, while ego may play a role, the core motivation is almost certainly the powerful lure of monopolization in modern e-commerce. It is an incredibly potent financial temptation.
How so?
Think about how search algorithms and product discovery actually work on a platform like Etsy or Amazon. If a consumer goes to Etsy and searches for a Hot Girls Read shirt, 5,000 different results pop up. If you are a seller, you have to fight tooth and nail to compete with all 5,000 of them for visibility, clicks, and ultimately sales.
You have to lower prices, run ads.
Exactly. You have to lower your prices, spend money on ads, and constantly optimize your SEO. But if you own the federal trademark, you don't have to compete. You just submit an automated DMCA-style trademark takedown request to Etsy.
And they just comply.
Because of those safe harbor provisions we discussed, yes, they instantly deactivate your competitors' listings. With the click of a button, you have legally eliminated 5,000 competitors. You become the sole monopolistic provider of a highly sought-after cultural commodity. The financial upside is massive. It was a calculated, albeit highly flawed and ultimately disastrous business risk.
And her risk assessment completely missed the reality of the modern internet. The internet never forgets, and it loves to keep receipts.
They kept all the receipts.
The community used the Wayback Machine to cache and save all of her infringing product pages. She couldn't just quietly delete the Taylor Swift bookmarks and pretend they never existed. The community had the evidence secured. They started organizing active campaigns on Reddit and Threads to mass report her storefront to Taylor Swift's legal team and Sarah J. Maas's publishers.
It was a full-on digital siege.
And then, amidst all of this chaos, the community discovered the ultimate, hilarious, fatal irony of her entire brand strategy.
Oh, this part is just unbelievable, yes. While Allie Rose spent 2 years of time, money, and mental energy trying to secure the rights to Hot Girls Read, she fundamentally neglected to protect her own core brand identity. She had completely failed to trademark her own actual business name, Allie Rose Co.
I literally cannot believe that detail. She built a business for 4 years. She amassed 60,000 loyal followers. She went viral multiple times. She managed to navigate the federal IP filing system for a slang phrase. But she didn't bother to trademark the name of her own store.
It is a cardinal sin in basic brand management, and the BookTok community realized her vulnerability immediately. According to extensive discussions on the Reddit forum at BookTube Snark Reddit, community members recognized that her brand name was legally unprotected.
So they went after it.
They did. Sources indicate that retaliatory filings were actually being drafted and prepped by angry community members to trademark Allie Rose Co. right out from under her. If successful, this would have effectively allowed the community to legally bar her from operating under her own established business name.
My analogy for this is, it is exactly like launching a massive military invasion into a neighboring country, sending all your troops over the border to conquer new territory, while leaving your own capital city completely unguarded with the gates wide open.
That's exactly what it is.
The psychological pressure on her at this specific moment must have been absolutely immense, almost crushing. Let's tally it up. You have a formal, publicly funded TTT cancellation proceeding filed against you, which you know you will lose because you lied on the timeline. You have an angry, organized mob of 60,000 former fans actively turning on you. You have the very real, existential threat of Taylor Swift's lawyers and Pantone's corporate litigators waking up to thousands of emails reporting your store for massive copyright and trade dress infringement. And on top of it all, people are trying to steal your actual business name.
The situation rapidly reached a forced climax. The pressure became unsustainable. On Monday, June 8, 2026, which is just 5 days after her initial triumphant celebratory post tight, Ali Mitrovic posted a new video to her Instagram account.
The apology video.
Looking visibly bewildered, clearly distressed, and facing absolute reputational and financial ruin, she announced her unconditional surrender.
I watched that apology video several times, and I found her specific choice of wording absolutely fascinating. What exactly did she say, and how did she frame her defeat?
The core of her statement was this: I'm so sorry to every small business that I harmed in doing this. This was more a business strategy decision than a human being decision, and that was entirely wrong on my end.
A business strategy decision.
That's what she called it. Crucially, she announced that she had formally applied to the USPTO to voluntarily surrender the trademark registration, effectively abandoning her rights and returning the phrase "hot girls read" to the public domain.
I have to push back on the sincerity of this apology, because when I hear someone frame a betrayal of their community as a business strategy decision, it feels incredibly calculated.
It does sound like PR.
Right. Was this a genuine, heartfelt change of heart? Did she suddenly wake up and realize the profound moral failing of trying to enclose the literary commons? Or did she just sit down, look at the math, and realize she was cornered?
She was definitely cornered.
She was facing a $1,200 community-funded legal strike that she was guaranteed to lose because of perjury. She was facing the terrifying prospect of multi-million-dollar lawsuits from corporate giants. Her entire revenue-generating customer base was actively boycotting her. Did she actually have a choice here? Or was this essentially a hostage video filmed by her own terrible decisions?
This raises an important question about the difference between public relations optics and cold, hard legal reality. Whether her apology was a sincere moral awakening or just a highly calculated exercise in desperate damage control almost doesn't matter from a legal and historical perspective.
The outcome is the same.
The structural outcome is what is critical here. Official documents filed with the USPTO confirm that the registration was expressly abandoned. She legally, formally relinquished the claim. The chain link fence was torn down.
And what happened to all that physical merchandise she'd already manufactured and printed? Because the sources show she wasn't just selling cheap stickers, she had high-margin apparel. She was selling a $55 maroon gingham mock-neck sweatshirt, a $25 varsity leather cropped tee.
As part of her attempt at reputational rehabilitation, she promised in her video that all profits from the remaining inventory of Hot Girls Read merchandise would be donated to 2 established literary charities to read and feed.
Okay, that's a nice gesture, at least.
Simultaneously and far more quietly, she rapidly scrubbed her website of all the infringing ACOTAR, Harry Potter, and Taylor Swift merchandise in a desperate attempt to mitigate her exposure to the corporate lawsuits the community had threatened her with.
But even in the midst of this complete surrender, there was still controversy brewing about her honesty, wasn't there? In the apology video, she tried to claim she hadn't actually hurt anyone yet.
Yes. In her public statement, she explicitly claimed that she had never sent direct takedown notices to any Etsy sellers. She was trying to maintain that she hadn't yet acted as the bully.
But the internet had receipts.
However, the internet, as always, brought the receipts. Multiple independent merchants stepped forward and provided documented proof. They posted screenshots of automated intellectual property takedown notices they had received directly from Etsy.
Oh, wow.
And those notices explicitly cited Alley Rose LLC's federal registration number as the reason for the takedown. So while she may not have sat at her computer and typed out individual personalized threat emails, she had absolutely utilized the automated algorithmic enforcement tools that the trademark registration provided. Her actions directly resulted in her peers' listings being deactivated and their income being halted.
It just goes to show you can't gaslight a community that knows how to take screenshots.
Mhm.
So the phrase "hot girls read" is free again. The park is open. But reading through the rest of the source material, this isn't an isolated freak incident. This is a massive, accelerating trend. People are waking up to the fact that internet culture is highly profitable, and they are rushing to plant legal flags everywhere they can.
Exactly. The digital land grab is not over. It is actively ongoing and it is accelerating. Savvy e-commerce merchants have filed federal trademark applications for a whole host of other phrases that were organically born from the online literary community.
Like what else?
We are currently seeing active USPTO filings for terms like book boyfriend, which is a universal trope denoting highly appealing fictional romance characters. Someone recently tried to trademark the concept of blind date with a book, which is a ubiquitous retail concept used in hundreds of indie bookstores where books are wrapped in brown paper with descriptive clues written on the front.
I've seen those everywhere.
Other communal phrases currently navigating the slow, bureaucratic trademark process include bookish AF, boy aquarium, spicy snacks, and spice trail.
It is honestly exhausting to think about. If every single inside joke, every beloved literary trope, every trending hashtag gets legally owned and walled off by a corporation or a highly aggressive Etsy seller, how can a digital community even function? You can't have a natural, spontaneous conversation if every third word you use requires a licensing fee or risks an algorithmic account suspension.
And that is the core fundamental business lesson we need to extract from this entire saga, both for creators and consumers. If you are a business owner, the lesson is clear: prioritize protecting your actual unique core brand identifiers. Protect your company name. Protect your specific custom-designed logo. Do that before you try to monopolize generic shared cultural memes.
Because the internet will come for you.
Because if you try to forcefully own the culture will aggressively audit you, and they will find your weak spots. And for consumers and small creators, the lesson is the incredible, undeniable power of organized collective action.
The legal precedent set by the BookTok community here is massive. As Josh Gerben noted in his analysis, because of this intense public controversy, there is now a substantial, permanent, publicly generated record of evidence proving that the phrase "hot girls read" is ubiquitous.
Yes, and that public record is a shield for the future. The community didn't just win this specific isolated battle against Ally Rose. They effectively poisoned the well for any future opportunists.
So no one else can try this.
If someone else attempts to quietly register Hot Girls Read in 2028 or 2030, the USPTO examiner reviewing that file will likely uncover this massive digital footprint. They will see the news articles, the archived Reddit threads, and the formal TTB cancellation filings. That history makes it almost legally impossible for the phrase to ever be successfully trademarked again. The community permanently secured the commons.
So why does all of this deeply technical legal drama matter to you, the listener? Why should you care about what happens on BookTok? Because whether you are a small business owner running a niche Shopify store, a consumer just looking to buy a funny, relatable sticker for your Kindle, or simply a person who texts internet slang with your friends, the boundaries of who owns culture directly and profoundly impact your daily life. It dictates what you are allowed to say online, what you are legally permitted to create, and what you are able to buy.
It touches everything.
It does. If we allow these vibrant public digital parks to be quietly fenced off by private toll booths, we lose the shared language that makes these online communities so creative and vibrant in the first place.
The law is inherently slow and bureaucratic, but internet culture moves at the speed of light. And as long as there is massive financial profit to be made from cultural trends, there will inevitably be violent friction between outdated intellectual property laws and modern internet communities. The Hot Girls Read saga is just one highly visible skirmish in a much larger, ongoing, invisible war for the ownership of our collective language.
Which brings us to a final, slightly terrifying thought for you to mull over as we wrap up. Throughout this entire case, we saw human beings, creators, lawyers, internet sleuths, battling over a trend that took months or even years to fully develop and commercialize. But we already know that algorithms currently dictate what goes viral. What happens when artificial intelligence gets fully integrated into this legal IP process? Imagine a near future, maybe just a few years from now, where fully automated AI bots are deployed by massive corporations to scrape TikTok and Threads in real time. The very second an AI detects a new slang term or a micro trend emerging in a subculture, it automatically generates a product design, uploads it to an e-commerce print-on-demand site, and simultaneously autofiles a federal trademark application with the USPTO entirely without human intervention.
That is a scary thought.
Right. If human beings are already successfully executing land grabs on our cultural phrases, what happens when ruthless machines can legally enclose the digital commons before we even realize a phrase has gone viral? Who will actually own our language then?
That is the daunting frontier we are rapidly approaching. It will require not just hypervigilant communities willing to crowdfund their defense, but a fundamental structural rethinking of how our legal systems process, evaluate, and protect shared human expression in a fully automated age.
We started today talking about a public park and the shock of seeing a chain-link fence erected around the swings you've used your whole life. In this instance, the BookTok community managed to organize, tear that fence down, crowdfund the legal bulldozers, and chase the toll collector out of town. But the blueprints for those fences are still out there. The tools exist. And the next person or the next algorithm that tries to build one might be moving a whole lot faster. Thank you for joining us on this deep dive into the sources, and please keep questioning the world of information around you.